A very good morning to all of you. So we would like to continue with our discussion of corporate finance. We'll be discussing shares, and the last time that we met, we had just started discussion of I think the difference between preference and equity share. And fundamentally, what we have to remember is that the law recognizes that the companies at liberty to create different types of shares and endow with the shares certain privileges, certain rights, and so on. So where a special class or group of shares have been created and certain rights or advantages or privileges have been attached to them, then within the scheme, within the language of our company law, particularly Act 992, that will be treated as a preference share. And that is why Section 51 will say that if you talk about preference share, it means a share which does not entitle the holder of the share to a right to participate beyond a specific amount of money in distribution, whether by way of dividend, on redemption, winding up, or otherwise. And any other share shall be referred to as an equity share. And more importantly, if you look at subsection 3, subsection 3 emphasizes that it is not so much about the label, it's not so much about the taxonomy or the nomenclature, which matters, but more importantly, it is a substance. It is what is contained in that particular share. And that is why subsection 3 says that preference has the meaning we have just seen with respect to section 51.1, whatever name a company may designate in its constitution. So therefore, in the constitution of the company, it may decide to create certain category of shares, certain types of shares, and may even give certain names to those shares. It will still be preference share. Insofar as by those shares, the holders are assured of a certain amount of money when dividends are declared, or the holder is assured that at some point in time, he or she can return his shares and get his money back. That is with respect to what do you call the redemption. Or should the company decide to return access to the shareholders, that particular shareholder is assured that he will get his shares or the money that he paid for the shares first. So that is a redemption. So if you are able to do any of this as a result of the shares that you hold, then we call you a preference share. So that is what we should note. And if you are not able to enjoy any of these special privileges, any of these special advantages, then the shares that you hold, you'll be treated as an equity share, or we call it ordinary share. So in the literature, if you come across equity share, ordinary share, we are referring to one and the same thing. So equity share and ordinary share, they mean the same thing. Yeah, so that is what we should keep in mind for now. And again, if you look at the being a preference shareholder, you are a shareholder to start with. And if you remember session 34, last semester when you were discussing membership of companies with Dr. Adakwa, you would have noticed that as a member or as a shareholder, at least in terms of section 34 of Act 992, your basic rights include the fact that you have the right to attend a general meeting of the company. You have the right to speak and vote on a resolution before the meeting. And again, unlike what the suggestion which was made in the case of Adishimine Gardens against Asibe, which I've asked you to read. If you remember, in Adishman Gardens against Asibe, the point was being made that, well, of course, not the court, I'm talking about like the parties. Some of the directors were trying to say that if you are a subscriber or a member and you have not fully paid for all your shares, then your rights as members cannot be enjoyed in full, as it were. And that is not correct. And the Supreme Court rightly said so, that that is not correct. And in fact, if you look at section 34.2, it emphasizes that so long as you have not made express provision. In other words, if you have not stated directly in the constitution, the registered constitution of the company that that is going to be the case, that is to say that if someone has not fully paid for his shares, maybe some of his right as a member or shareholder, maybe be it the right to attend and vote, is going to be suspended or truncated. Now, if that has not been done explicitly in the registered constitution of the company, then you cannot pick and choose when you allow a member to enjoy his right of attending and voting at meetings. Yeah, so that is 34.2. So 34.2 say that yes, if the company wants to do what the directors in Adishman Gardens were trying to do, then the constitution of the company to have actually stated that where you have not actually paid fully, or especially so when calls have been made on you, then we are going to prevent you. Yeah, so that is the only instance. So having said that, class reader, just quickly read for us.
Dr. Dapa, please, should I read section 34.2 or
52.1?
Section 52.1, suspension of voting rights of preference shares. Subsection 1, despite section 34, the right of holders of preference shares to attend and vote at a general meeting of the company may be suspended on conditions. Subsection 2, despite a provision to the contrary in the constitution of a company, preference shares carry the right to attend general meetings and on a poll at those meetings to at least 1 vote per share in the following circumstances, but not otherwise. Paragraph A, on a resolution during the period that the preferential dividend or a part of the preferential dividend remains in arrears and unpaid, the period starting from a date not more than 12 months or a lesser period that the constitution of a company may provide after the due date of the dividend. Paragraph B, on a resolution which varies the rights attached to those shares. Paragraph C, on a resolution to remove an auditor of the company or to appoint another person in place of that auditor. Or paragraph D, on a resolution for the winding up of the company or during the winding up of the company.
Okay, good.
Subsection 3, apart from the circumstances in section.
Yeah, thank you, Esther. Yeah, so what the point about section 52 is that we are being reminded that just as every shareholder, as we under section 34, is entitled to attend and vote at general meetings, the same thing applies to preference shareholders. However, when we are discussing section 34, we noted that 34.2 allows the company, where it has made provision in its constitution, to say that where a shareholder has not finished paying or certain other stated circumstances exist, such a shareholder may be prevented from actually exercising the right to attend and vote. That is now, section 52 is saying that in the case of preference shareholders, Such a possibility contemplated under section 34 is not applicable. In other words, the right of a preference shareholder to attend and vote at a meeting is not, if you like, amenable to the changes which the company can make in terms of what this constitution provides under section 34(2). But for preference shareholders, the right to vote can be suspended only on strict conditions. But even where the right to vote can be suspended, regardless of what the constitution of the company is saying, there are certain matters in respect of which a preference shareholder can always attend and vote when those matters come up, irrespective of whatever conditions that might have been specified in the constitution of the company, are saying that, well, the right of the preference shareholders may be suspended and so on. So those matters which automatically entitle a preference shareholder to vote and to attend and vote at the meeting, even where the suspension of such preference shareholder will have been possible. Those matters are what we have in subsection 2. So therefore, if, for example, the company ought to have paid the agreed dividends, that's the preferential dividend, the fixed or the specified dividend, the shareholder, and same has not been paid and is in arrears during the period that the company is owing the preference shareholder, when issues are coming up to be decided, so long as the company has been owing the shareholder for 12 months or so, he is entitled to vote on that matter, regardless of whatever the constitution of the company says. And again, whenever there's going to be a resolution change the rights attached to the shares which the preference shareholder holds, also entitled to attend and his right can never be suspended. And again, when you are also going to move an audit, the preference shareholder cannot be suspended in terms of attending, regardless of whatever the constitution of the company is saying. And of course, the same thing also applies to winding up when you are trying to wind up the company. So these are the matters that you have to keep in mind. So we have to know on our fingertips circumstances under which a preference shareholder can never be suspended in terms of attending and voting at the meeting. Of course, if you look at the heading of section 52, it's a bit misleading in the sense that it takes our mind to the suspension of the preference shareholders' right to vote at general meetings. But I think more importantly, what is reminding us is that, yes, it is possible to suspend the right of preference shareholder to attend and vote at general meetings. But more importantly, there are certain matters, there are certain issues which have been protected by the law that when those matters come up, the preference shareholder can never be suspended. And even if he's on suspension, he can still attend and access it. So let's keep that in mind. And of course, we are also told that just like what we saw in section 34 and 33, that if you are a shareholder, your rights, your share at least entitle you to have one vote when we have to vote and things like that. So that is not difficult at all. But if we look at the subsection 3, it is drawing our attention to a certain development. There's a case which is called Faith. I don't know if at our last meeting, of course, it's not this class, it's the part-time people that I have mentioned, but for you to, reference is made that the case of Bushel and Faith is a very old case, but is very interesting because it concerns or deals with the possibility of having what they call like the weighted voting. And the weighted voting simply, it was creating the possibility if maybe certain matters are going to be decided in the company, then some of the shareholders, their votes, their shares will not just carry, if you like, one vote each. It will carry more than a vote, probably 3 votes or 4 votes or whatever per each share, as it were. And for that matter, if you look at like the Michelle and Faith, in those days, I mean, in the 70s, they had like a very small company, and it what do you call the registered constitution, had weighted voting provision. So the members, brother and 2 sisters, they were the shareholders, and the brother was the MD or the executive, and each of them had 100 shares in the company. And the sisters, that is the members, were not happy with how the MD or the CEO was running the affairs of the company. They became aggrieved and things became very bad, and decided to vote to move him as the managing director. Now, there was a clause in the constitution of the company, that is the article of constitution, and that clause was that any director who had to be removed from the board will have 3 every share that he holds. In other words, if you're going to be voted to be removed as a director, then automatically your vote will gain more weight, so that each share that you had will not just carry 1 vote, it will carry 3 votes. And that is what we call like the weighted voting. And eventually, when it got to the court said that yes, as far as there was that clause, the weighted voting in the constitution, it was not within the power of the members. Just remove them, because the MD, as also a shareholder, his vote had that weighted voting. So if you are voting, you also vote, and his vote will count, will carry more. His shares will carry more votes than you, because he was the one being removed. So if you look at 154, 3 and 4, you is also referring to like the possibility of this voted in. So take 3 and 4 together right away for us, Esther.
Section 52, subsection 3. Apart from the circumstances in section 34 and subject to subsections 1 and 2 of this section, preference shares carry the right on a poll at a general meeting of the company in respect of each share. Subsection 4. A special resolution of a company increasing may validly resolve that an existing class of preference shares shall carry the right to the vote specified in subsection 3, additional to 1 vote per share, as shall be necessary in order to preserve the existing ratio, which the vote exercisable by the holders of those preference shares at a general meeting of the company bear to the total vote exercisable at the meeting.
All right. So
subsection 5. For the purposes of subsection 2.
Yeah. So
subsection 5. For the purposes of.
Yeah, go ahead.
For the purposes of subsection 2, a dividend is due, paragraph A, on the day immediately following the expiration of the year or other period, or B, a company has a registered constitution on the date appointed in the constitution for the payment of the dividend for a year or other period, whether or not the dividend has been earned or declared.
Okay, so what we gather from the foregoing subsection 3 and subsection 4, as I said, is that it is possible if the company is interested to create some sort of, if you like, the weighted voting rights for certain preferred shareholders. That is possible, and that is why subsection 4 is saying that yes, if the preference shareholders have a certain ratio in terms of the number of shares have in relation to other equity shareholders, where you are going to, for example, increase the number of shares of then automatically they may be entitled to additional vote in addition to their usual 1 vote per share, so that they'll be able to protect the ratio that they have. That is the balance of number of shares that they have per their category in relation to other class of shareholders. And finally, we also get an idea, because if you look at the 52 1 and 2 that we read, that where the company is in arrears regarding payment of dividend, then during that period, the preference shareholder cannot be suspended. So the question is, when can we say that the company is in arrears? And that is where subsection 5 is reminding us that, well, there are 2 ways of going about it. One is that as soon as dividends are declared by the company, then a day afterwards, what that means is that the company is obligated to pay the dividend. Dividends are due. Or if you take if the company has a registered constitution, it can also indicate that, okay, these are the circumstances when the company can be owing you dividends after declaration of dividends and all that. Yeah, so all those matters can be worked out. And just the other side is that if you are not a preference shareholder, you are equity shareholder, as we have seen already. And being an equity shareholder, the basic principle which we saw in discussion of membership per section 34 is that a share carries 1 vote. Yeah, so that is a elementary principle, and we should keep that in mind. And so if you look at it, the possibility of bushel and fate scenario, which allows, if you like the weighted voting, is not really possible with respect to equity shares or ordinary shares, as it were. Because if you look at the 53 1, it is quite emphatic that despite a provision in the constitution of the company, equity shares carry the right on a poll at general meeting of the company to 1 vote only. So the bushel and fate scenario that, well, if you are as a director or when this thing is coming up, your share will count as 3 votes and so on and so forth, is not really possible with ordinary or equity shareholders. And that is the sense we get from section 53 of Act 992. So let's keep in mind. Yeah, so if we look at the subsection 2, is making the point that an alteration of the rights of issued preference shares so that the equity share is an issue of equity shares. In other words, if you have passed the necessary resolution to say that you are going to change the rights which are associated with the preference shares, and for that, so that they become just like the equity shares, then when you do that, the preference shares will no longer count as preference shares. They will be treated as equity shares, ordinary shares. And for that matter, as we know, 53 that equity share is entitled to 1 vote per share. That will be it. Anytime issues come up for meetings. So let's keep that in mind. Now, we would like to look at certain details or some other types, subtypes, as it were, of preference share. There are various variety of preference shares. So let us look at that. And we get that sense from section 54. And the reason why I say that section 54 provides us the various types or categories of preference shares is that if you look at the what do you call like the sessional heading, the session is headed Canons of Construction of Class Rights. So class rights certainly relate to preference shares. If you say class right, what are class rights? Class rights simply means that you have classes of shares, and the various classes of shares have got unique rights associated with those classes. And for that matter, if you are not a holder of shares in that class, you cannot enjoy the rights associated with that class. You cannot enjoy those class rights. And that is also what makes you a preference shareholder, because you've seen that a preference shareholder simply means that you have been given certain rights or privileges in relation to other payment of dividends, distribution, or return of income or assets of the company. Yeah, I've seen that somebody's hand is up. Mention your name and then ask your question. Okay, the person whose hand is up, mention your name and ask your question.
Okay, please, Michael.
Michael, right.
You said that yeah, ordinary shares, they have one share per vote, or so 1 vote per share, something like that. So I want to understand, is it that when no matter the shares that he have, he is entitled to 1 vote, or if he has, for example, 50 shares in the company, his vote is 50.
All right. Thank you, Michael. That is a very helpful question. So that one, and Michael's question is simply that when we say that equity share has 1 vote, does it mean that he has 1 vote as in relation to all the shares that he has in the company, or each share in the company actually carries a certain number of votes? Okay, the answer is that if we say that a share carries a vote, that is to say that if you have the total number of shares that you have will determine the total number of votes. As you rightly said, if you have 50 shares, each of the 50 shares carries 1 vote. And if you remember discussion of membership, from session 31, 32, 33, 34 last semester, you have noted that when we're having meetings, there's something we call polling. It's not all the time that in company meetings, we say that we are going to let 1 share, 1 vote, or we are going to let the number of shares that you have to determine the number of votes. Now, where we are letting the number of shares you have to determine the number of votes that you can cast when an issue is being decided, we call that polling. We call that polling. So, but ordinarily, if you're having general meetings, sometimes we may just have what they call like the head count, just count the people who are present. and that's it. Except where a member insists that he would like polling to be done. In other words, he is not satisfied that we just counted the heads, like the number of people who are present that support or that are against the motion. Say that let us do polling, meaning that let each shareholder have as much say on the matter we are discussing according to his pocket. And his pocket means that according to the number of votes that you have. So that if you have more shares, you have more votes, you have more say. And of course, having more shares means that you have put more money in the company. Yeah, so that is it. Good. So let's move on. 54A. Reader.
Section 54, Canons of Construction of Class Rights. In construing the provisions of the constitution of a company in respect of the rights attached to shares, the following canons of construction shall be observed. Paragraph A. Unless the contrary intention appears, a dividend is not payable on any shares unless the company resolves to declare that dividend.
All right.
Paragraph B.
Yeah, so as we have said before, having a share means that you're entitled to returns we call dividends. But fundamentally, you can't just say that dividends should be paid to you. Dividends are only payable or can be paid when the company has made declaration that yes, this profit can be treated as dividends. So when profit has been treated or has been declared as dividend, it will be there and then that you will be entitled to a dividend, as it were. I'll call you later. It will be there and then entitled to dividend, as it were. So let's keep that in mind. B.
Paragraph B. Unless the contrary intention appears, a fixed preferential dividend payable on a class of shares shall be cumulative. In other words, a dividend is not payable on any shares ranking subsequent to that class of shares until all the arrears of the fixed dividend have been paid.
Okay, good. Now, before I explain the B, let me bring to your attention that if you look at the 54, you notice that some of the paragraphs begins with unless the contrary intention appears. So what that means is that what the provision is telling us is what we call the default rule. The default rule in the sense that it's permissible for the company to make alternative arrangements. But where the company has not made alternative arrangement, then the position of the law is the default rule, which we are being told in the respective paragraph. So that for preferential shareholders in respect of that is where a shareholder is entitled to fixed preferential dividend. Then the default rule, that is if the company has to make alternative arrangement, the default rule is that it is cumulative. And being cumulative simply means that when, let's say, the dividends are declared in the financial year 2021, the dividends which were declared, for example, were not enough to be able to pay all fixed preference shareholders with respect to dividends. Because let's say that it may not be just only one fixed preference shareholder with respect to dividends. So if there are many, all of them will have to pay and all that. So let's suppose the dividends declared are not enough. So when they are not enough, what will happen is that the portion which remains unpaid will be treated as an arrears, which will be carried forward into the next year or the next financial year when dividends are declared. So that when dividends are declared, let's say in 2022, the arrears from 2021 will have to be paid to the relevant preference shareholders before they get their dividend for that current year, that is 2022. And when they have had that, then the company will be at liberty to pay dividends to other shareholders, that is the ordinary or the equity shareholder. So that is what it means to say that first preferential dividend is cumulative. Yeah. So let's move on to C.
Paragraph C. Unless the contrary intention appears in a winding up, arrears of a cumulative preferential dividend, whether or not earned or declared, is payable up to the date of actual payment in the winding up.
Okay. So when the company is winding up, you discussed with Dr. Adakwa a couple of weeks ago about the corporate restructuring and insolvency. You know, when it comes to closing the company, we have what they call the members voluntary winding up. So members voluntary winding up simply means that the company is solvent, and the company being solvent means that the company has enough assets to be able to pay its debt and liabilities as they fall due, at least within the next 12 months, and then the 12 months preceding the decision to wind up. So that is, when you see the company is winding up, that means that it is solvent. We're not talking about situation of insolvency, no. Because if the company is insolvent, you are not just winding up, it's going to be liquidated, and the other principles will kick in. So where the company is winding up, meaning that the company is doing well, but for whatever reason, the members say that let's close the company. Now, if there's a preference shareholder in such a company, what 54 paragraph C is telling us is that decided to do winding up, then all arrears of dividends which have not been paid will have to be paid. And again, it doesn't even matter that maybe the financial year has not actually ended and so on and so forth, because you are going to close the company. And first preference, first preferential shareholders with respect to dividends, they are entitled to a certain fixed return. You have to pay them everything. And that is why we are being told that even if it is not earned, if it is not earned means that maybe it's not the case the financial year has ended and then profit, no. So long as you are going to close the company, they are automatically entitled to be paid their agreed fixed preferential dividend. So maybe that, let's say that if the person is entitled to 10% fixed preferential dividend of maybe whatever profit to be declared, or of the value of the money he paid for the shares, whatever, with the number of permutations which may be used as far as first preference share with respect to dividends is concerned. That will be the situation. So let's move on to D.
Paragraph D. If a class of shares is expressed to have a right to a preferential dividend, then unless the contrary intention appears, that class does not have a further right to participate in dividends.
Yeah, so we have what we call the participating preference shareholders with respect to dividends, and non-participating preference shareholders with respect to dividends. So if the particular preference share was created and the document creating that does not indicate that it is a participating preference share, automatically the law is saying that being a preference shareholder will be deemed as non-participating. And what do you mean by non-participating? That is to say that when dividends are declared, because you're entitled to a fixed dividend, and then your fixed dividend is also cumulative, meaning that if there are arrears from previous financial years when dividends were declared, it will be carried forward to the subsequent financial year and all that. Now, after your fixed dividends have been taken care of and other shareholders have been also be given their dividends, supposing the company did so well and there is still money, there is still the other dividends remaining. Now the remaining dividends will be shared among shareholders, and you as a preference shareholder will be excluded from the surplus or the extra dividends left. So that is the point section 54D is making. E.
Paragraph E. If a class of shares is expressed to have preferential rights to payments out of the assets of the company in the event of winding up, unless the contrary intention appears, that class does not have a further right to participate in the distribution of assets in the winding up.
Yeah, so the E is the other side of D. So the D was talking about fixed preference, preference shareholder in respect to payment of dividends. And we are told that as a default rule, it is non-participating. Now, E is talking about fixed preference shares in relation to return of capital. And we are also being told that it is non-participating, meaning that if you are preference shareholder, your preference is with respect to return of assets, meaning that when the company needs to maybe return assets to shareholders, you are guaranteed that all the money you put in the company will be returned to you. Now, when that happens, you actually be giving all the money you put in the company. However, after you have been giving all that to put in the company, the other shareholders are also giving theirs. If the company was doing fantastically well, there will still be surplus assets. And because you are a fixed preference shareholder in relation to return of assets, you are not going to be allowed to participate in the distribution of the surplus assets. Yeah, so that is the point he is making. Yeah, F.
Paragraph F. In determining the rights of the various classes to share in the distribution of the property of the company on a winding up, consideration shall not be given unless the contrary intention appears.
Yeah, unless the contrary intention, I think we've lost our reader. Unless the contrary intention appears to whether or not the property represents accumulated profits or surplus, which have been available for dividend while the company remains a going concern. I mean, this is an accounting principle with respect to determine the property which is available for distribution on winding up, and how preference shareholders will get theirs. Yeah, so it is just for our information, and those who do the accounting aspect of it will have to factor it into determination of what is really available to be distributed. And the G is reminding us that subject to this session, that is, except the person under 54, shares rank equally, all respects, unless the contrary intention appears. That is to say that, as a general rule, shares enjoy equality. There is no discrimination. The only exception is where the company has gone out of its way to create preference share, the term we're discussing so far. Yeah, so we move on right away. That's issue of share certificate. So who will, is the reader back?
Yes, please.
Okay. So section 55.
Section 55, subsection 1. Subject to the Central Securities Depository Act 2007, Act 733, a company shall within 2 months after the issue of any of the shares of the company or after the registration of the transfer of a share, deliver to the registered holder of the share a certificate certified by one director and the company secretary, indicating A, the number and class of shares held by that holder and the definitive numbers of the shares. Paragraph B, the amount of money paid on the shares and the amount of remaining unpaid. And paragraph C, the name and address of the registered holder.
Okay, so before we move on, 55 is talking about what we call the evidence of shareholding. Now, if you say you are a shareholder of a company, what is one of the easy means of proving that you are a shareholder? Of course, in Adeshiman against Asibe, we all noted that there are so many ways, including when your name has been entered in the register of members. But quite apart from that, one means, which is very important, is the certificate. So that is a document issued by the company and executed or signed by the director and the company secretary, giving us information regarding the number of shares which the shareholder has got. And we also told that the definitive numbers of the share, when we say the definitive numbers of the share, what it means is that if the company was registered with, let's say, 1 million shares, let's suppose that 10,000 shares have been issued already. Now we are going to issue 5,000 shares to you. Now the definitive number of your shares will be from, let's say, 10,001 to 15,000. So that is the, if you like, the definitive number. That is what we mean. And also the amount of money that you paid for the shares, and also amount remaining unpaid will have to be indicated on the face of the certificate, of course, as well as the name and address of the holder. Now, the only is where a company does not have to issue share certificate is where the company has its shares or securities being dealt with under the Central Security Depository Act. Now, there is something we call dematerialization. There's something called dematerialization. So if you look at this, let me probably put it here. Dematerialization. Yeah, it's not part of the provision, but just for purposes of our discussion. Yeah, so if you go to the Central Securities Depository Act 2007, there's this concept of a dematerialization of a share certificate. What that simply means is that for companies that are listed on the stock exchange or whose securities are being dealt in under the framework set up under the Central Security Depository Act, they are excused from issuing paper shares and paper share certificate. They don't issue paper share certificate. So, shares are denoted by maybe other numbers or some other things in a digital form. So dematerialization means that you have converted from paper share certificate to, if you like, the either digital or number, as it were. Now, what is the legal effect of the information contained in the share? Now, before we move on to that, just to remind you, we are not going to read the entire provision. You can read it that. Yes, if for whatever reason you get your share certificate destroyed or lost or defaced, you're entitled to request the company to reissue it to you at a fee, which the company will determine. Yeah, and But where a company has refused to issue a share certificate, after giving shares to you, issuing shares to you, once after that, they don't give you a certificate, you take the necessary legal action against the company. And please, you have to mute yourself. If you are, it's only the class with those will remain unmuted. The rest, mute yourself and raise up your hand if you want to talk. Thank you very much. Yeah. So that is 2 months after the shares have been issued, the company will have to issue the certificate. If the company does not do that, of course, the veil will be lifted. The responsible officers will be sanctioned. So that is the point. But more importantly, what is the legal effect of the share certificate? What does it mean in law? So let's look at section 56(1).
Section 56(1). Statements made in a share certificate under the common seal of the company or as certified by 2 directors and the company secretary of the company are prima facie evidence of the title to the shares of the person named in the certificate as a registered holder and of the amount of money paid and payable on the certificate.
Okay, thank you. This is very interesting. If you remember, when we are discussing mechanics of incorporation under section 15, we are told that the certificate of incorporation is a conclusive evidence, and the emphasis is conclusive. Conclusive meaning that it is irrebuttable or irrefutable, as it were. But in the case of share certificate, the certificate is not conclusive. It creates a rebuttable presumption. And that is why we are being told in 56(1) that the share certificate issued under the company seal, prima facie evidence of the title to the shares of the person named in it. Prima facie evidence means that unless there is a countervailing evidence to contradict what is stated on the face of the share certificate, the person so named will be considered to all intent and purposes as the holder of that share. Yeah, so pay attention. Whereas certificate of incorporation constitute conclusive evidence of due incorporation, share certificates constitute a prima facie evidence. Yeah, so pay attention to that. And because it's constitute prima facie evidence, yes, you can place reliance on the share certificates in terms of the information contained on it. And in fact, a person can use his shares to raise, to be a security, let's say to raise a loan or to guarantee something. Let's say that if you present that you have a significant shareholding in a well-to-do company and all that, maybe on basis of that, if you go to a bank or any other institution to go and raise a loan or something like that, it will be prepared to actually give it to you, thinking that yes, what the document is saying is true, that you are the owner of those number of shares. So that can be done. But what about where there is an error and the bank rely on the share certificate and it turned out that the information stated on it is not true? Now, where that is not true, then according to section 56(2), what that means is that the company which issued the share certificate will be stopped, will be precluded or prevented from denying the statement made in the share certificate. So that if you have stated that I have 10,000 shares in Tullow Oil Ghana, and let's suppose that I don't really have 10,000 shares, I have just 100 shares, and I'll be able to use the 10,000 shares certificate to go and support maybe a loan I am raising from a particular bank, because the bank thinks that yes, if you have 10,000 shares in Tullow Oil, then that is fine. So later on, the bank becomes aware that my share was just 100. And for that matter, the loan will not have been given to me, or the quantum or the amount of loan that I was given will not have been given to me if the bank had known that I did not have that number of shares in Tullow Oil Ghana. And that is why Section 56(2) is saying that in that sense, the company which issued the share certificate will be held to the information, and will not be allowed to deny that what the document is saying is not true. So, Section 56(2), if we look at the Gowers report, we have an old cases like the case of Blumenthal against Ford, a very old case, 1897, appeals case 156, as well as the case of Sheffield Corporation, Sheffield Crop against Buckley, 1905. C392. Now, before I say just a brief word about one of these cases, let me remind you that, as I have said before, company law is heavily positivistic, meaning that most of the law is really enacted, and the primary law is Act 992. The case law is secondary. And more importantly, if you take a case law which is saying nothing more than just what the statutory provision is saying, then the case law is just for purposes of what? Illustration. Yes. Yeah, so the case law, as I said, is just for purposes of illustration. Now, last semester, marking your exams, and I'm sure the results will be made. I don't know if the results have been released to you, but they are ready. Marking your exams, the observation I made was that when you are talking about, especially those who are doing problem-based question, when the pre-incorporation contract and those kind of things, you discuss the old common law as if it's more important than the specific provision of the Companies Act. Now, this is a proper approach to take. When you are dealing with a problem-based question, I'm talking about problem-based question. If there is a relevant provision of the law, let's say the Company Act, 2019 Act 992, you must start from the statutory provision before, if there is any case law which has clarified, interpreted, or applied that provision, before you move on to do that. And don't treat the statutory provision as unimportant or as secondary. No. We tend to make that mistake as students in the common law jurisdiction, because in law of contract and the law of tort, most of the principles are in case law and we don't have legislation. That thinking is very much of us. And even when it comes to company law, where 90% of the law contained in legislation, we still want to treat the legislation as unimportant and the case law as more important. And that is a more reason why, for a good number of topics, I prefer to discuss the law with you. And if there is any relevant case law that is added, rather than just talking to you and then we make a perfunctory reference to the statutory provision. Yeah, so please, let's keep that in mind. So in Blue Minter against Ford, as I said, it's just the principle in Blue Minter against Ford has actually been codified in section 56(2), that the statement, if there's a false statement made on the share certificate, which has properly been issued by the company, then the company will be stopped from denying the truth of the statements made on the face of the share certificate against a person who might have changed his position in reliance upon the false statements in the certificate. So that is Blue Minter against Ford. And as I told you, it's not different from what section 56(2) is telling us. And that is why you will not do well if you ignored section 56(2) and just started talking to us about Blue Minter and Ford, knowing very well that Blue Minter and Ford has now been reduced into statutory provision. So what happened in Blue Minter and Ford? In Blue Minter and Ford, Blue Minter lent money to a company on terms that he should have as security fully paid shares in the company. And he was handed 10,000 shares as fully paid up to the tune of £10,000. Nothing had in fact been paid on the shares as stated, contrary to what had been stated on the share certificate. And Blue Minter did not know that the information was untrue. That is the information that 10,000 shares have been issued to him and they have been fully paid up £10,000. He didn't know that that was not true. And eventually, when the company went into liquidation and all that, the matter eventually got to the House of Laws, and the House of Laws rejected argument made by the liquidator, because the liquidator had argued that Blue Minter was liable to pay the full nominal value of the shares. That is the 10,000 shares Blue Minter will have to pay, because it had not actually been paid to the company. And the House of Laws rejected that and made the point that the company was stopped by the share certificate from denying as against Blumenthal that the shares were fully paid. In other words, Blumenthal and Ford is reinforcing Section 56.2 that if you put wrong information on the share certificate and someone relies on it to his detriment, then you will be held to what the document is saying. Of course, where the company has suffered a loss, the company is entitled to be indemnified. Entitled to be indemnified simply means that the officer in the company whose neglect or whose omission is responsible for the false information contained in the share certificate, which someone has relied on and the company has suffered a loss. The company will be entitled to sue that person or take whatever means to recover the money that the company has made to lose as a result of the false information on the share certificate from that person. So that is the point subsection 3 is making. And of course, we have stated that where shares have actually been transferred to the scheme established under the Central Security Depository Act, and so that the share certificates have been surrendered and they have been immobilized. Immobilized means that the company has taken custody or has taken over the share certificate which was previously issued and is going to, as it were, destroy it or translate it or convert it into a non-paper version. So it's going to take it through dematerialization. In that case, the company will not actually have to worry itself about what this provision is saying regarding a share certificate, because the company is no longer operating the share certificate regime as it were. Okay, so this brings us to one of my favorite topic in corporate finance, the doctrine of capital maintenance. The doctrine of capital maintenance is a very interesting area of corporate finance, and it's very nice for us to start discussion of it. And before we start discussion of the relevant provisions, like when we say capital maintenance, what do you mean? Or what doctrine is that? Well, by the doctrine of capital maintenance, we have to go back to maybe the very old case of the case of Trevor and Whitworth. Maybe let me put it that way. Let's start from the case of Trevor and Whitworth. And 1887 decision. Good. In Trevor, I mean, you don't need the citation. 12 apps. Oh, 09. Now, in the Trevor and Whitworth, what we call the doctrine of capital maintenance was actually enunciated, and simply that as a general rule, a company is not supposed to reduce its capital unless authorized by statute. That is, the capital, the money, which the company has raised by issuing shares should be conserved, should not deliberately be reduced, except in strict accordance with the law. So the basic principle, as far as capital maintenance is concerned, is that a company should not pay share capital back to shareholders, except in circumstances permitted by the Companies Act or by law. And if you wanted to put it in historical context, the capital contribution of shareholders was intended to provide some security for the company's creditors. And the law lays down strict and, of course, complex rules in relation to reduction of capital. Although we know that in reality, if you look at today, share capital constitute relatively, if you like, a minute component of money available for financing the company. And for that matter, the capital maintenance doctrine we have does not provide the type of protection which in the past was expected will be providing to the company. Because today, I just give you an example. I know a certain rural bank, for example, in which I'm a shareholder. I think I have about 120,000 Ghana cedi shares. The rural bank, let's say, it has the total state capital it has is about, I think, 2 million, I think 800,000 Ghana cedis. That is the share capital, the money that he has raised from giving out shares. But the total assets of the company is about 190 million. So certainly, the share capital is relatively regarding the amount of money available for that company. Nevertheless, we still need to appreciate the doctrine of capital maintenance, that once the company has raised money by issuing, the money so raised should be conserved and should not be returned to shareholders. And if it will be depleted at all, probably through normal trading losses, because once the company is trading, it can make profit, it can also make losses. I mean, that one is legitimate, and that one is not seen as a violation of the capital maintenance rule. So having said that, I would like us to start reading the relevant provision. So let's start with section 57, reader.
Section 57, subsection 1. A company limited by shares may, by special resolution, determine that a portion of the unpaid liability on its shares, which has not already been called up, shall not be capable of being called up, except in the event and for the purpose of the company being wound up. Subsection 2. Where a resolution is passed, that portion shall not be capable of being called up, except in the event and for the purpose stated in that subsection.
Okay, so company has issued shares, and at least from Adishman and Garden, we get the sense that yes, you can be issued shares and you haven't paid fully for all the shares, or the company itself may, for example, indicate that for the shares that you have been issued, maybe pay 70% of the value of the shares, and then the remaining 30%, you hold on to it until the company asks you or make a call on you to come and pay. So that is a sort of like a reserve liability, so that the company knows that maybe for the shares that it has issued, if for nothing at all, it has 30% of the value of the shares that it has issued, which is still with shareholders. And that is some kind of like, if you like, a reserve, is a reserve liability, reserve money, which the company can fall on in really, really a bad time. So that is, possible. So let's move on to section 58. Section 58 used to be section 56 in the repealed Companies Act 1963 at 179. And that is the proper statement of the common law doctrine of capital maintenance in Trevor and Whitworth. Yes.
Section 58, subsection 1. Except as provided in this act, a company shall not A. alter the number of its shares or the amount of money remaining payable on those shares. B. Release a shareholder or former shareholder from a liability on the shares. C. Provide financial assistance directly or indirectly for the subscription or purchase of the shares of the company or the shares of its holding company. Or D. Acquire by way of purchase or otherwise any of its issued shares or any shares of its holding company.
Okay, good. Now, section 58(1), containing what we call the prohibited transactions. Yes. That is those type of activities or those type of transactions which the company is prevented from indulging in with respect to its shares. Daniel, I'm teaching. I'll call you back. With respect to its shares, I would like to remind you of what happened in Trevor and Whitworth first. In Trevor and Whitworth, basically, a company purchased the shares of a member, but did not pay for them. And then the executors of the W, like the disease, claim the price. I mean, the executors of the claim the price from the liquidator. In other words, there was a company, somebody had a share, you decide to buy the share back, but no payment was actually no money was raised for that purpose. So eventually, when the company had to be closed down, it was realized that it was an empty. Yeah, and because of that, the lawmaker, in its wisdom, is saying that under no circumstance should the company, for example, should the company change the number of its shares. That is a general rule. Of course, I wouldn't say under no circumstance. As a general rule, the company should not change the number of its shares. And why is it so? The company, if you remember from Mechanism Incorporation, when it is registered, it's registered with a certain number of shares. And that number should be kept. If shares have been issued, and if not all of them have been issued and still remain on it, at least at every point in time, you have a good sense of the capital strength of the company as well as the shareholding power. And again, the amount of money remaining payable ordinary can also not be changed. That is, if you saw that under section 57, you might have paid for part of the money intended to be paid for the shares. Another part remains unpaid. 57 allows that. But 58A, part B, is saying that that amount which remain payable, which is yet to be paid, the unpaid liability on your share should not, as a general rule, be changed, because it is money which belongs to the company. And even if the shareholder has not been made to pay, as and when the company needs it, the company can always ask the shareholder to come and pay the unpaid value. And again, and that is why if you were a shareholder, in the sense that maybe like you transfer your share to someone and there was a debt on the share, a debt on the share in the sense that you are not fully, you are not finished paying fully for the shares. That is a debt which will have to be paid. And that's when it needs to be called upon. Or should it happen that the company is liquidating, then as we know, when we're discussing limited liability concept, that yes, limited liability concept simply means that once you have fully paid for the shares, then no one can ask you to come and pay towards the extra debts of the company. On the other hand, if you have not fully finished paying for the shares, then in the event of the liquidation of the company, you'll be called upon to come and pay for the unpaid value of the shares. And again, we also noted when we are discussing, payment for shares that have been issued, that where you paid for shares in kind, during liquidation, the liquidator, when he goes through the books and he gets to know that maybe what you used to pay for the shares was really overvalued, meaning that you got more shares than what you deserved, then you could be made to pay for the difference. I mean, apart from this limited situation in which you could be asked to pay more money, ordinarily speaking, once you have paid for the value of the share, that is it. However, if there was still an unpaid debt, unpaid liability, then you'll be called upon to pay. And that is why 58(1)(b) is saying that you shouldn't be released from the debt on your shares. Of course, this is a general rule, and pretty soon we'll see how the Companies Act provides circumstances in which you can do some of these things in a manner which will not be treated as derogation from the capital maintenance doctrine. And C, the company, the Ashantis have a proverb that if you cut your tank, maybe if you are looking for meat to enjoy, you cut your tank and you chew it. You've not really eaten any meat, or not, you are actually just deceiving yourself, because your tank is already part of you. So if you have chewed it, nothing new is coming to you. And that is why section 58(1)(c) is saying that a company is not supposed to give money to anybody to acquire its shares, because fundamentally, the purpose of issuing shares is to let you raise money. So if it is let to raise money, why will you give money to people to come and buy shares? The very money that you are giving shares out so that you are giving that money away. So that is why there's a general prohibition of financial assistance for acquisition of the company shares. But as I said, this is a general position, and pretty soon we'll see how exceptions are permitted. And again, very much of the case in the Trevor and Whitworth, that is the 58D, that the company is prevented from buying its own shares. If the company has issued out shares, The shares were issued in order to raise money. So the company should not buy those shares back, because if you're buying those shares back, you definitely have to give money out. And that was why Lord Herschel, and I hope you remember Lord Herschel, because Lord Herschel, of course, you've met him in the case of a dairy and pig. Lord Herschel was also one of the judges who decided the case of Solomon and Solomon, alongside with the what they got, the Lord, I think Magneton, Lord. Who were the other laws in Solomon and Solomon? Can anybody mention the rest? Alif, Esther.
Doctor, please, the one I remember is Lord Magneton.
Yeah, Lord Magneton. Okay. All right. Okay. Yeah. So Lord Herschel in Trevor and Whitworth made this dictum, and I quote: "The capital may no doubt be diminished by expenditure upon and reasonably incidental to all the objects specified. A part of it may be lost in carrying on the business operations authorized. Of this, all persons trusting the company are aware and take the risk, but I think they have a right to rely and were intended by the legislature to have a right to rely in the capital remaining undiminished by any expenditure outside these limits or by the return of any part of to the shareholders, unquote." Yeah, so a company must not give its money back with respect to shares which it has already issued out. Now, what I would like you to move on to, let's move on to the subsection 2, and then, yes, subsection 2 and 3.
Subsection 2. For the purposes of paragraph D of subsection 1, shares are acquired by the company if they purport to be held in trust for the company, although they are registered in the names of nominees. Subsection 3. Subsection 1 does not prohibit a company from voluntarily acquiring its own shares on the conversion of the company to a company limited by guarantee in accordance with section 9.
Okay, so we are being told that yes, if you have a trust and then you maybe the company, the company has created a trust and shares have been acquired by the trust, and the company is the beneficiary, it will still amount to the company acquiring its own shares. And in that respect, the principle of separate legal personality will not apply, insofar as the company is the beneficial owner of any such acquisition. And then we know that it is possible for a company limited by shares to change its character and become a company limited by guarantee. And where that is the case, if you remember, section 9 requires that all the shares in the company limited by shares must have been fully paid up. And once they have been fully paid up, the members should be prepared to return the shares to the company so that there are no issue shares. And they will now make undertaking regarding how much money of the company's debt they are prepared to actually bear in the event that the company is winding up. So where fully paid up shares are being voluntarily surrendered or returned to the company so that the company can become company limited by guarantee, that is not considered as a violation of the capital maintenance doctrine. So let us keep that in mind. And that is the point section 3 is trying to. Now, where you have actually breached this prohibition, where you've actually breached this prohibition then it triggers lifting the veil in the sense that the officers and those who are responsible for the company doing any of the things that it is generally prohibited from doing will be made to pay the requisite fine. And even if you look at the 4B, where money has actually been lost to the company as a result of indulging in any of those prohibited transactions, you have to even pay interest on the money that you have caused the company to lose as well. So that is a very serious matter. So what will happen is that tomorrow, at the same time that we met today, we have a class, and we finish at 9, and we will continue. So I will pause here and take any questions that we may have before we end the class. If you have a question, just raise up your hand or anything like that. Yes, the bless.
Doctor.
Oh, sorry, the bless, go ahead. The bless, please, go ahead.
Hey, Doctor, please, can you hear me?
Yes, I can hear you now.
Yes. So please, my question is, when there is an outstanding balance to be paid on a share and dividends are declared, are the members entitled to the full dividends they are actually entitled to, or because there is an outstanding balance to be paid on the shares, the dividends are going to be decreased or something?
Right. Thank you, the bless. That is a very important question. Now, first and foremost, we have to remember that the share is contractual, and it all depends upon the terms of the issue. If under the terms of the issue, you are not supposed to pay the full value, and only a part thereof or portion of it is supposed to be paid, and you have paid that, and no call has been made on you. A call being made on you means that no demand has been served on you to come and pay the unpaid one. Then, when dividends are declared, you're entitled to full dividends, and your dividend is not going to be diminished by the unpaid liability because you haven't done anything wrong. Except where the terms of issue, for example, have actually stipulated that if you don't finish paying, then that is what the position is. Any other? Okay, so in absence of further questions, this will mark the end of the class this morning. And tomorrow at 7, we have another class. And tonight at 7 p.m., I will be at the faculty auditorium, I think, with the part-time students. Of course, there will be repetition of some of the things that I have taught you. If you still want to sit in, since it's the same course, you are free to sit in. Otherwise, tomorrow be in the Zoom class at 7 a.m. for us to have continuation of our class. So have a very good day.